Welcome to A Way Forward, the right to recover.
Welcome to A Way Forward, the right to recover with attorney Richard Casey, partner at Robinson Casey. Richard focuses on helping families navigate legal options when addiction or serious mental illness creates an urgent safety concern. His work, including the Marchment Act and mental health guardianship, as well as advocacy around treatment, access, and oversight. I'm Lisa Mosby, and today we're talking about mental health guardianships, specifically when the Marchman Act doesn't apply and families need a different legal path. Thank you for being with me again today, Richard.
No, thank you for having me again.
Richard, to start, could you explain what a mental health guardianship is and how it differs from a Marchman Act case?
Yeah, absolutely. A mental health guardianship is very similar and akin to a regular guardianship proceeding. But most people are just familiar with the types of guardianship or conservatorship that comes with an aging parent, right? Someone who's the affirmative aging has caught up to them, and then we're going to step in and care for their estate, their assets. But there's also the need sometimes to step in earlier in life when an individual suffers from the type of mental illness that prevents them from making decisions around their own well-being, their own finances, their own medical concern, who they socialize with. Maybe they don't have the ability to drive because it could be dangerous. That could be from any number of conditions. So, what our firm focuses on is really those types of mental health cases, which are really severe enough to have them really suffer from a permanent incapacity. That might be because of substance use, but more often than not, it's due to some other serious mental illness. And so it differs quite a bit from a Marchman Act. A Marchman Act is an involuntary treatment statute. It is designed to help families petition the courts to get their loved ones into treatment, to designate a specific period of time that they'll be in treatment at a particular level of care to start, and it allows them to continue to monitor their success or lack of success or compliance or lack of compliance with treatment during that period of time. A mental health guardianship involves the determination of whether or not they have the capacity to exercise any number of a certain rights on their own. And that really is the premise of any guardianship, is not what we think of as a guardianship, but a petition to determine incapacity. Do they have that capacity innately in themselves, or is it required that somebody else ultimately make these decisions for themselves? Or if someone else couldn't make these decisions for them, do they have to be removed and not delegated to anybody else? And so when we're talking about mental health guardianships, we're really talking about a family who may not have durable powers of attorney, who may not have healthcare surrogate designations, or otherwise known as medical powers of attorney, in place. And we know that their loved one is likely incapacitated because of their serious mental illness. And we're going to ask the court to go about finding that they don't have the capacity. And then from there, we will look at what rights can we assign to the guardian, right? And who should that guardian be? And so we're not necessarily putting them in treatment, but we are shifting the ability to decide what medical decisions are appropriate for them out of the patient's hands, who ultimately lacks the capacity, into a different decision maker's hands, who has not only the capacity, but the willingness to assist in getting their loved one, or getting their ward, as the individual is called, to the types of services that they need.
I'm following that difference, that comparison. And then in what kinds of situations does the Marchman Act legally not apply, even though the family may be facing a serious mental health crisis?
So the Marchment Act is a wonderful law, but it is not a silver bullet. It's not a one stop fits all. So when an individual has no substance use, there's no alcohol misuse or abuse, there's no cannabis misuse or abuse, the situation is exclusively mental health, and the loved one is suffering from a diagnosed or even undiagnosed but clear, right, incapacity, then the guardianship would be the remedy. It would be, we have to step in, but because there's no substance use at all, the Marchman Act wouldn't apply. The inverse of that is to say, if they have an extreme serious mental illness and there is moderate substance misuse, even mild substance misuse, such as, let's say, cannabis. I'll use an example. If someone suffered from schizophrenia and had mild cannabis use, but following their initial diagnosis of schizophrenia, they were informed that any cannabis use would be contraindicated with their schizophrenia diagnosis. So any use of cannabis would be an abuse. It would be a misuse. It would be such a more drastic situation for a person diagnosed with schizophrenia to use any cannabis than for that same amount of cannabis being used by a non-schizophrenic. And so the Marchman Act may very well apply there, right? We have to look at all of the facts and circumstances and how frequent and the most recent use of cannabis and so forth. But when there's none, the family with the schizophrenic loved one is looking at it going, why can't I use this treatment statute? And the Marchman Act does not apply in that circumstance. And so one of the things to consider would be looking at guardianships, mental health guardianships, to prevent the schizophrenic patient from refusing medical treatment that's appropriate, from signing themselves out of the hospital when they otherwise should, from keeping their loved ones from receiving their medical diagnoses information or updates from the hospital for releases of information, from managing their own finances, from driving, from choosing who they hang out with, who might be trying to take advantage of them if they do have finances. So allowing us to really kind of get our hands around the patient a little bit more completely when they suffer from such a debilitating illness. And ultimately, that's not the perfect Marchman Act type scenario. And so the mental health guardianship offers an alternative.
And then how does the guardianship impact medical decisions, making treatment, access, and ongoing care for someone with serious mental illness?
So having a mental health guardianship, or just a guardianship in general, it really matters exactly which rights were removed and which rights were delegated. But primarily in this mental health guardianship, we're looking at the rights to determine residency, the rights to consent to medical and mental health treatment, the rights for selecting their social environment, to keep them in certain social environments or out of certain social environments. We might want to restrict their right to travel without the oversight of their guardian, so that they're not just traveling without any supervision or help. And what it allows for is the family to engage with the doctors directly. The guardian themselves, who may or may not be a family member, would be able to have the authority to communicate with the doctors, to get their medical updates and information, and to consent to the required regimen of treatment. That doesn't mean that the individual can be restrained by the type of provider who doesn't have the authority to restrain. If you go into your local primary care doctor can't strap you to a gurney. He's just an outpatient doctor. So the guardian could consent to the process of medical treatment and the recommendations, and ensure that the prescriptions are approved and filed and filled and given to the patient. But the doctor at the primary care facility is not going to strap him to a gurney and inject him. But there are then options of, if it was getting serious, the guardian can go back to court, ask for additional authority, can work with law enforcement to keep the ward safe, can enroll them into higher levels of care, and can work amongst the medical system to really ensure that the right types of services are being delivered or could be delivered.
Do you find that there are some common misconceptions families have about guardianship that you find yourself clarifying early on?
Yeah, I don't think that most families go into life thinking that they want to learn about guardianships at all,
Yeah.
right? It's kind of thrust on them in the unfortunate circumstances of whatever's transpiring in their life. So there are a ton of, I think, misconceptions from movies or TV, um, or from a different state that maybe hit the news that has nothing to do with the state of Florida, or how things are potentially done as a whole. And so when you have a loved one who needs a guardianship, for the most part, particularly in Florida, if they are located in Florida, even if their residence is somewhere else, the family can act. They don't have to bring them home and they don't have to file it in their home state. If you have an individual who is suffering from a mental illness, who's going through a crisis now, I shouldn't have to figure out how to get him back home before I can file. And I shouldn't have to file in a state he's not located in and ultimately wait for an examining committee of doctors to somehow find the patient in another jurisdiction. In Florida, file where the patient's found, literally in the county where they're located at that moment, regardless of residency. And I think that's really important to know, is that we can ultimately step in and help families whose loved one might end up in Florida for any number of reasons. It's not designed to be restrictive. It's designed to protect the ward from themselves and from abuse of others. It's designed so that if they're in a position where they can't take care of themselves, wherever they are, it's about protecting the ward. And it's primarily the ward being protected from the ward themselves and the ward being protected from people who want to take advantage of them. The other thing that it's not is that it's not a statute designed to protect other people from the ward. Someone has, when I first started practicing this area, it was kind of put this way. It's not pre-crime, right? It's not, if the ward is going to go out and do X but hasn't done it yet, we should do this to the ward to stop them from ever getting the thing that they haven't yet done, right? It's not pre-crime. It really is that going to hurt the ward? Because it is preemptive protection of the person the guardianship's over. And so it really needs to come from that lens.
And how does the court's role in a guardianship case differ from its role in the Marchment Act case?
Well, they're two totally separate functions, and they have different statutes, and they have different procedures technically. Um, and so the court is really there to protect both patients, but one is hearing the evidence of a Marchman Act case and entering an order for them to be in a treatment facility, and then relying upon that facility to give updates as needed. They might order the facility to give status updates, but more often than not, the order is for a period of time and it ends automatically unless the facility and the family come back and recommend more time, right? Or ask for more time. And then they would be forced to prove their case in full again that more time is appropriate. Whereas a guardianship, there are emergency temporary guardianships that are really only there to bridge the gap of day one until I get a permanent guardianship. The idea is if someone's not capable of exercising a particular right, they're not going to say, well, let's check again in 90 days, like, and reprove your whole case. They're going to take that right away from the ward. And then they're going to oversee the entire guardianship for the duration. And so they don't leave. And so it's not come back and reprove your case, come back and reprove your case. It's, I'm going to give this authority to this guardian. And then I'm going to sit here. And if you want to do certain things, you got to come ask for permission. If you want to continue to be the guardian, you'll send me your annual reports. You'll give me an annual accounting. You'll show what's being spent, what it's being spent on, where they've been in treatment, what they're doing. And so the court really's goal is they have really broad discretion to do whatever is necessary to protect that ward and oversee that estate. And so you go and you pray for relief. In other words, they're constantly there in the background, constantly concerned about the well-being of the patient, and you have the ability to ask for whatever you might need to ask for, and they're not restricted by nuances of the statute. There are nuances of the statute that must be followed, but if you needed something that was never contemplated before, that judge is authorized to consider all of the facts and circumstances about what's best for the individual ward and make the decision that's appropriate. So they're there to help you continue to protect and care for the ward, potentially in perpetuity.
So, what comes to mind, or what I'm thinking about, is for families who are deciding between waiting, pursuing a Marchment Act, or even exploring guardianship. What perspective helps them focus on the appropriateness rather than fear? Because there has to be some fear here for some folks.
Yeah, I think that fear is probably one of the biggest reasons that people delay. Um, the fear of the unknown, the fear of the threats of losing the relationship. And so when they're contemplating getting care for their loved one or not, I kind of empathize. When I was 21, my father died from alcoholism. When I was 20, I went to his intervention, and he really wasn't willing to go to treatment. And I ultimately was the person in the room that said I would never speak to him again unless he went to treatment. And it was successful. My plea for him to go did work in that moment, but I was willing to say the things that other people weren't. And I knew that I was taking this risk. I might never speak to him again. If he had said, no, I won't go to treatment, I had to be willing to back up my statement. And if he said, yes, he would go to treatment, I may not have found success. He may not have gotten sober, and I may never speak to him again. So it is a really tough choice, one that I've been faced with, and one that I have moved on. And I was then the patient thereafter. I would not change what I chose to do. I would hold a strong boundary, because if I didn't do that, there would have been no sober days in between my dad's intervention and his passing. There would have been very unlikely the same length of time. He would have likely passed away much sooner. And I wouldn't have had the positive memories of being able to see him get better, have him admit some of his weaknesses, and maybe in an unrelated component, give me the strength to go into my own recovery journey when I knew that he had tried himself. But I just think that families are going to suffer fear, and they haven't, like I said before in a prior meeting, really, they haven't been trained on how to hold boundaries. And so this Marchman Act or guardianship really allows you to put some of the boundaries on the court and help guide you. So if you initiate this process, ultimately you have the chance of keeping guardrails in place without you having to have all of the strength yourself. And so if you don't have all of the strength yourself and you need the help of others, you may have a better chance of getting your loved one the help that they need.
Sounds like it. Thank you so much for today, Richard.
Thank you.
That's it for today, folks. Today's episode of A Way Forward, the Right to Recover. If you'd like to learn more about Richard and the work of Robinson and Casey, including resources related to mental health guardianship and the Marchman Act in Florida, please visit RobinsonCasey.com. Thanks for listening, and don't forget to like, subscribe, and share this episode with a family who may need it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.